think, very topical and important panel. And so I want to start by just laying out what the issue is and inviting Arul to perhaps comment on what we are seeing around us. So this is something that affects, I think, everyone who writes in any fashion or capacity, because what we are seeing nowadays is that these large language models, LLMs, uh, that we use in our daily lives, or many people use, ChatGPT, Gemini, all these large language models that have become really a part of many people's daily work. These models are so responsive and so quick and so efficient because they are trained on human made material, in particular, writings of human beings. And that brings about a dilemma because under copyright law, the right to these writings vests in, the rights holder. So perhaps you could begin by just, commenting on the legal issues. So how do we understand the copyright implications when something like ChatGPT is trained on books written by human beings, on other kinds of material authored by human beings, which is within the scope of their copyright?
So, good morning, everyone. I hope I am audible, right? So, first of all, it's a really great pleasure to be in conversation with someone like Gautam. The reason why I'm specifically mentioning is when I mentioned that I'm going for KLF and Gautam is the one who is going to ask questions. A friend of mine asked me, is he going to ask questions as a lawyer or as an author? So I don't think there is anyone better than Gautam for a discussion like this. So of course, one of the things which I also want to ask Gautam at a later point is how he views the developments in this area as an author. So maybe let's start from there before I answer the legal issue. So how do you see as a lawyer the coming in of the ChatGPT
As an author? Yeah, I think, I mean, the magazine that I edit, we have a pretty strict no AI policy, and I think it's really important for us to know that, both the writing, of the piece as well as the artwork, has been effectively made by a human being, because many complications arise when it's not that. So we try and filter it out, but it's quite hard. Yeah.
Great. So now one of the things which you could very clearly see from the response of Gautam is the emphasis on human authorship, right? So it's very evident that he as an author prefers to ensure that whatever output he is dealing with is authored by a human being. Something similar could also be seen generally in the context of copyright law, because if you look at the genesis of copyright law, you will notice that yes, this is a law that was in response to human creativity. Of course, this emerged in the context of printing press. There, yes, the copyright law aimed to prevent the mass dissemination of works without the permission of the author. So that's one background which we need to actually keep in mind while we engage in a discussion like this. Now, coming specifically to the question which Gautam asked me, there are two important things or two different stages which we need to keep in mind in the context of large language models. The first one is the input side and the other one is the output side. So it is a fact that millions of books, articles, and other kinds of text materials are used for the purpose of training all these large language models. And in general, the quality of a large language model depends also on the kind of materials it has been trained on. So it is a undisputed fact in all the litigations. Now, one of the questions which the copyright law or the judges will have to answer in almost every major jurisdiction is when books are used for the purpose of training or books are for that purpose, any blog post written by Gautam or any other materials written by Gautam, if they have been used for the purpose of training, does that result in infringement of copyright? So that's one, I would say, important dimension of the issue. The second important dimension is, what about outputs that are generated by large language models? So as you all know, Gautam very frequently writes op-eds, right? So imagine that as part of an output which is generated by ChatGPT in response to a query which you post, it is also producing in verbatim or maybe in a substantially similar manner an output which is similar to what Gautam has already written. Does that amount to infringement? So these are two, I would say, different layers of copyright issues that we generally see in this particular area, and both of them have to be dealt with separately. So that's also one important thing which we need to keep in mind. So the kind of approach which we might be taking with respect to the input side may not be the same which we might be taking with respect to the output side. And one of the general things which I am observing in litigations across the world is that we are moving maybe more away from the output side, more into the input side. That is, in other words, the question is now mostly focusing on whether the use of copyrighted materials for the purpose of training constitutes infringement. Again, there is a reason, because as you might have also noticed from many of your personal interactions with these large language models, the number of instances wherein a verbatim output is produced by large language models, at least the major ones, have gone down drastically because of the kind of safety measures these models are actually putting in. So because of that reason, we are generally seeing in most of the jurisdictions a shift more into the input side.
What are these safety measures that you were mentioning?
So generally you will notice that they are putting in kind of filters. So imagine that I am asking ChatGPT to generate 10 pages of the wall which was written by you. Most probably the response would be saying, no, this is a copyrighted material, I cannot produce a output in verbatim. On the other hand, if I am going to summarize the wall for me as a user, most probably it will actually produce that particular result. Again, one of the very important things which we all need to also keep in mind is that the copyright law has never prevented those kinds of uses. For example, if you are summarizing the op-ed which is written by Gautam or a novel which is written by him, it was never found as infringement, whereas if you're producing the content in verbatim, it was considered as infringement under the copyright law. So that's also the reason why, yes, these filters are actually now preventing or trying to prevent verbatim reproduction. Of course, I mean, if there is the so-called extraction attacks happening on these large language models, most of the evidences prove that, yes, they can still produce, but yes, you need to now put in some amount of effort to actually produce a condense in verbatim.
You know, this actually makes me think of something because on Twitter recently I posted a book that I had read, and in the comment section, people were asking Grok to summarize, the book, and Grok had a summary of the book which was pretty accurate.
Nice.
So I was wondering, I mean, did Grok have access to the book itself, or was it using a compilation of reviews on the open internet? Where do you think that came from?
So again, I mean, in the context of large language models, we need to understand that things happen currently at different stages. One is, yes, there is this general training which has happened, and most of them have a cutoff date. So most, since the book which you are mentioning, I presume that it's a very recent book.
2017, yeah.
2017, most probably it must have been in the training corpus. Right. So it's quite possible that this was also part of training. But imagine that I'm talking about a book which was released, say, in December 2025. In all probability, that was not part of the initial corpus. But in those instances, what the models are now doing is they're also kind of combining a search-like function wherein they query all these recent writings and then produce a result also based on that. So again, in those instances, should we treat it as a infringement? I very much doubt that.
Yeah, I'll tell you a funny story. Actually, one of my academic books is published by Hart UK or Bloomsbury, and for the last year, they have been sending me emails that please give your consent. This will benefit you to like letting your book be part of the training corpus. And I have not replied to those emails because I don't want to reply to them. And
Can you also explain why you don't want to
well,
reply to
I'll
them?
come to that. Yeah, and the thing is that this publishing company, since the book was published, has been very unresponsive to my requests. So whenever I request, like, can you please have differential pricing, in Kenya and India? Can you, like, bring the price down? They never reply. They always ghost me, and they've been ghosting me for the last 2 years. But they've been very persistent suddenly about this. In fact, even like the actual editor of the publishing house, who never responds to my emails, sent me a personal email saying, long time, can you please, go and do this? So it's really funny how persistent publishers are to try and get authors to give their consent to having their, books part of the training corpus. I don't want to, because again, I don't want my work to become something that then, AI is trained on and then can replicate later on. Because again, I think it's just some feeling about the sanctity of the human process in creating, a literary piece, or a piece of work. But I just want to actually come to the issue of copyright itself. I think it's a related question. Now, I write fiction and non-fiction, and for fiction, my royalties are, I think, for one book, perhaps like 2,000 rupees, over 6 months. And for one book, there are no royalties because it's not yet sold enough copies to, become a royalty-producing book. I think that's the story for most of my fiction writing colleagues. So unless you are a bestseller, and I mean like a proper bestseller, you can't make a living of what copyright gives you, which is royalties. And similarly, in nonfiction, a little better, but it's still, you can't make a living off it. And so, one thing that's been true across the years has been that authors, or the creators, haven't really been served particularly well by copyright as a legal regime. We can't earn a living off it. But what we are seeing now is that the only means of protection that we have against this AI, using our work to train on, is the law of copyright. And so I know many US based science fiction writers, for example, who really don't like copyright, and they say, like, we don't like it, doesn't work for us, doesn't work for our readers, it's just a bad system. But we have no choice but to join these litigation lawsuits, because all that we can invoke for protection is copyright. So how do you see this tension between copyright never really having been about protecting the interests of writers and creators, vis-a-vis now being all that you have to rely on to protect your work from AI?
So again, I mean, a great point. So if you look at the way copyright is functioning today, what Gautam is trying to say is very correct, be it literary works, be it musical works, because in the context of literary works, many a times the concerned copyright is owned by the publisher. So when Gautam, say for example, is publishing, of course Gautam is a smart lawyer, so I know that he will negotiate properly and ensure that he doesn't transfer his copyright. But in most instances, what is happening is they take an assignment from the concerned author for all kinds of rights that is existing today, as well as things that might come tomorrow. Of course, in some jurisdictions like ours, there are certain restrictions put in this particular regard, but it remains a fact that many of the publishers, and even for that matter, the music companies, try to take away the copyright from the actual creators. Then yes, it becomes a question of also justice. Yes, can they actually then claim that their copyright is serving the interests of the author? So I think that's a very valid question, and this definitely needs to be addressed. But having said that, I just also want to go back to the point from which you started, that is, yes, in your case, Heart, the publisher was generally not responding, but suddenly there is a wake up,
Yeah.
and then they are asking whether yes, you can sign this particular agreement. There is a reason which I think most of you should also be knowing. The fact is that most of these publishers now want to enter into agreements with these big AI companies. So in the US, for example, you will notice that Anthropic has gone for a settlement with OpenAI, and as part of that settlement, around 500,000, that is 5 lakh works are becoming part, and the general estimate suggests that most of the authors or the copyright owners will be getting around $3,000 each as part of that settlement. How many actual authors are going to get that or not, I think I leave it to the future. But yes, there is money on the table and the publishers definitely want to take it. And in some instances, like what Gautam mentioned, then the authors may not also want to actually then allow the publishers, or for that matter, whoever else is a copyright holder, to actually make use of that opportunity. But I am seeing that issue, this issue of whether we should allow AI to train based on our works in a slightly different manner. For example, if I ask this audience, how many of you use ChatGPT or something similar on a regular basis, I can kind of guarantee that 90% of the people who are sitting here would be using it on a regular basis. Of course, there can be debates on what regular means in this context, but it is a fact that yes, it has become part of our life. If that is the case, maybe it is in the interest of everyone that more works, better works are allowed to be used for training. For example, I want Gautam's non-fiction works to be part of the corpus training, because if someone wants to actually know about the legal position, say for example on bail, the constitutionality of denial of bail and so on, because I mean he writes extensively on issues like this, I want the best outputs to be generated and used by the public.
But so just a question on that. So do you see a difference between fiction and non-fiction in this context?
So I would say yes, because it is a fact that even though this should not be the way people should be using all these large language models, it is a fact that more and more people are now using these large language models for getting relevant information. It might be medical information, wherein yes, ideally people should never be using, but it might also be, say for example, legal issues and so on. For all these matters, people are now relying on these large language models. So if they have to give information in at least a relatively accurate manner, it is very important that better corpus of materials are available for training. For that reason, when another publisher, so Cambridge University Press asked me the same question, do I want my work to be allowed for training? My answer was yes, because if people are using it also as part of their information retrieval process, or in other words, similar to a search engine, then maybe it is in the collective interest that we should allow more works to be used for training purposes. Of course, on what conditions, that is a debatable one, but in general, maybe that is desirable. In this regard, I might also want to add one more thing. Please always remember that these large language models are producing only probabilistic output. So it is just making a probabilistic output that, okay, the next sentence or the next word in a particular sentence should be this one and not the other one. And it is a miracle that most of the time they're getting it correct, but yes, always remember it can also be wrong. So for that matter, yes, we should allow more materials to be used for training purposes. In the context of fiction, yes, it improves, again, I mean the kind of language outputs it is generating, but I still think maybe there can be a different approach there.
Yeah, I think what you said about the probabilistic point made me think of, so I'll come back to this question in a moment, but before that, I just have a bit of a funny question for you. So recently, I took a Supreme Court judgment, and I won't say which one. It was reading very strangely. Something was off about that judgment, and I've been reading judgments for 12 years now, and often I struggle with them. I was struggling in a very different way with this. Something is off. The word choices are not quite making sense. So I took an excerpt from that Supreme Court judgment, and I copy pasted it into a detector, AI detector, which of course is not accurate, not perfect, but I got 100% probability, that this is AI generated. I took the next paragraph 97%, the next paragraph 100%, 94%, and this went on for a few pages. Then I stopped. I was getting a little tedious, getting a little tedious. But I guess my question is that if people substantially write their pieces using AI, then who has copyright in that? Is it the person itself, or can they claim copyright if they've just you know typed a prompt into ChatGPT saying, "Give me a judgment on X topic"?
Again, I mean, that's a great question. So, if you look at most of the jurisdictions, you will notice that the answer might be no one might be owning copyright in those outputs. But with respect to India, I might be a bit more cautious in answering it that way. And I am saying that because of one very fundamental mistake our copyright office did in one application. So there was an application titled Surya. So this was actually a painting which was generated by an IP lawyer in Delhi. And what he did was he used one of these AI tools, and then he put as input Vincent van Gogh's Starry Night, and then asked it to generate a painting. So it produced a painting which he named as Surya's. He went to the copyright office seeking registration. Our copyright office initially rejected that application because in the applicant's column, he had put Raghav, which was the abbreviation of the concerned a model. But what happened subsequently was a more interesting thing. That is, the same person, the lawyer, went back to the copyright office, but this time he also put his name as a joint author in the application. Without any thinking, without any deliberations, what our wonderful copyright office did was they granted copyright registration for that work. If you look at the provisions of Indian
Wait, so
copyright,
now he is the joint copyright holder of an AI generated Van Gogh painting. Yeah.
Absolutely. So, and this is really ridiculous because if you look at the provisions of our copyright law, it is quite clear that they had never envisaged a non-human being as a joint author. But our copyright office has done this, and now the only way to remedy or correct this mistake is by approaching the High Court under the relevant provisions of the copyright law and getting it revoked. Initially, the copyright office said, yes, they are going to do that, but to the best of my knowledge, they haven't done that so far. So the net result is, in the Indian context, this is completely messy. But on the other hand, if you look at more IP-friendly jurisdictions like the United States and so on, they have consistently rejected these kinds of applications. So there was, for example, one instance wherein someone actually used more than 500 prompts to generate a particular painting, and there also the copyright office said, it doesn't matter whether you have reached or used more than 500 prompts. At the end, we cannot clearly say that it was all those prompts that only resulted in this particular painting, because as most of you would know, the large language models are even today to a great extent a black box. So we really do not know whether it is our prompts or whether it is many other factors that is actually producing a particular output. And as long as that continues, ideally the position should be that there shouldn't be any copyright law. But yes, unfortunately, many people are under the belief that if you are using one of these large language models and then generating a result, you become the copyright owner. Please be very careful about that, because I am sure at one point our courts will also clarify that that may not be the case.
Well, they may write an AI judgment to clarify that, right? I think yeah.
That's an unfortunate reality.
But so I just wanted to. I mean, I'm just curious though. So this lawyer, he created an AI version of Van Gogh's painting.
Yeah.
What will he do with it? I mean, what benefit does he have by having copyright over this AI painting?
So this lawyer, who is also a good friend, as far as I know, did this as an experiment.
Okay,
So
like
he
a test
wanted
case.
to test whether India is a jurisdiction wherein something like this will be allowed copyright protection. So he used a picture which was taken by him plus Van Gogh's painting and then generated this particular painting. But my firm belief is that even he may not have expected our copyright office to do a mistake like this. But now, what will he do with this? I really do not know. And in an ideal world, and I think this might also address many of the concerns which many authors have, that is, yes, it is a fact that today a purely other human generated work has to compete with millions of AI generated works, and that's a sad reality today. And maybe the solution is also not within copyright law but outside copyright law. For example, one of the technical solutions could be watermarking works that are generated by or with the help of AI. And if we can have that kind of a differentiation, I am sure that half of the anxieties which we are currently seeing will also go away. For example, ask yourself, would you be willing to pay even 100 rupees for a painting that is generated by AI? Most probably the answer would be no. Same goes with respect to music. So if we can distinguish between human authored works and AI generated works, maybe many of these issues will be resolved. But I again re-emphasize, the solution may not be within copyright law. Within copyright law, yes, we can do one thing, we can re-clarify that only human generated works will be given copyright protection. But yes, the bigger solution lies elsewhere, that is, the public should be able to distinguish between a human generated work and a machine generated
So
work.
transparency is what you're saying.
Absolutely.
Yeah.
Absolutely.
Yeah.
That is what we should be doing. Unfortunately, again, there we are not taking much
Yeah.
measures.
No, I think it's interesting because I'll tell you one thing they do in literary festivals is that a science fiction writer is always put on the AI panel. So over the last like 3 years, I've been in multiple AI panels because they always say, "Oh, science fiction, let's put you on the AI panel." So a couple of years ago, we were on, and there were four of us science fiction writers. All of us on one AI panel, and the question was that because for example, on Amazon, like the Amazon is own self-publishing vehicle. I think about like a 10,000 AI authored fantasy novels are uploaded every day to Amazon self-publishing portal, right? So I mean, it's clearly the present now, and so human writers are competing with AI generated novels, especially in fantasy, because often it comes through tropes and so on. And what the consensus was that what will happen maybe 10 years later is that the dominant set of novels will be AI authored, and human authored will be like handcrafted cheese, or like hand brewed beer, where it's like a boutique kind of thing where you pay more for the experience, like the flawed human experience. But that actually brings me to, I think, the question I wanted to ask you, following on from the last discussion, which is that, so the basic idea now is that, okay, you are the copyright holder or your publisher is. This is a form of property, intellectual property, right? And as with other kinds of property ownership, you can consent to waiving your rights over it. So look, the AI company, as you said with the lawsuit, right? The AI company will pay you some money, and you take the money and you sign your right away, right? So then don't complain after that, because you have been compensated for consenting to transfer your property rights in this piece. Now, first of all, to me, that I think it just reveals the absurdity of thinking of property as the framework to think of creation, right? So I think that's to start with, it seems absurd to think of creativity in the lens of property. But I think more seriously, for the future, what someone like me would worry about, and I think what fiction writers would worry about, is that, okay, so you sign away, your property rights in this piece of work. The AI is trained on, like you said, more and more good work. It becomes better and better, and at some point, it's basically indistinguishable, right? And that basically means that human writers no longer are required in society, and so, and therefore, when you are signing your rights away, you are not just consenting on your behalf, but you are impacting the creative careers of people after you, right? So what I'm asking is that, do you think that like property and consent are the right ways to look at this, or are there more issues involved here that you can't capture through the lens of property and consent, because you aren't just consenting for yourself, but the impacts of your consent will have downstream effects on just how quickly and how effectively AI authored works can replace human creativity?
Yeah, I think this is a very interesting question. I mean, whether our consent has like implications beyond, say, for example, our generation, particularly in terms of the future creativity. And it was also reminding me of another very recent development that has happened. That is, I do not know how many of you have followed this news. Now, Wikipedia is signing an agreement with most of these big tech companies to me, this is a huge shock. So I know that, yes, the Wikipedia founder is also at KLF, and we are celebrating 25 years of Wikipedia. But one of the things which I was asking myself when I saw that news is, did Wikipedia go back to the contributors, that is the editing community, and ask them, do you really want this to happen? Because
But how would you do that though? Because Wikipedia is so distributed.
exactly.
Yeah.
So again, I mean, I, for example, contributed to Wikipedia thinking that yes, I am then becoming part of a global knowledge commons. I want that commons to remain like that. But now, with these kinds of agreements, what is happening is that a knowledge commons is given on a platter to the big tech companies who are still not very clear whether they are going to keep their outputs open to the general public in the long term. Of course, I mean, we all have access to the free version of many of these large language models. But as most of the studies indicate, yes, these people are also burning money heavily now. And it is quite possible that almost all of them will move to a closed subscription based model very soon. At that time, then yes, there is also a question, isn't this your output is also a result of some of the contributions made by me? So your question on consent, I think, becomes very important. Now, my response there would be, yes, again, I mean, in the context of consent, what we really need to do is to ensure that we have informed consents in these circumstances. The authors need to be aware of what are the potential consequences of their agreement to this. In many instances, my general view is that people are giving consent not for money, but for something else. But yes, what are those something else? I think there needs more clarity. And if there is more clarity ex ante, maybe many of the concerns will be addressed. And I again want to re-emphasize, I am at least one of the persons who believe that machine creativity cannot substitute human creativity. I, as a consumer, still want to consume human authored works most of the time. Of course, I'm not denying there would be a competition. And again, this anxiety is reflected in many of the recent litigations, including the meta litigation in the US, wherein the judge can be seen putting forward a new theory called market dilution theory and saying that, yes, if you are letting this happen, what is going to happen is these works will have to compete with maybe millions of machine generated works, thereby everyone's value will go down. But my general sense is that if there are technical and legal measures which will help consumers to distinguish between the two, we should be able to address this issue. And I also want to add here that the platforms will have a major role in this particular regard. For example, if any of you have recently tried to upload any video on YouTube, one of the questions YouTube asks is, did you use AI for creating any part of the video? And then you have to click yes or no. Of course, as it stands now, there are no consequences for lying there. But imagine that there would also be legal consequences for you. Maybe many of the issues will be addressed. And the same is applicable to other platforms like Amazon, wherein, as Gautam was rightly pointing out, thousands of works, I mean, thousands of machine generated works are getting uploaded every day. But if there are consequences for lying on the platform with respect to the question of whether this was a machine generated work or human generated work, maybe we will be able to address some of the concerns. That's my general.
Yeah, I mean, soon after ChatGPT became a thing, one of the major science fiction magazines, Clarkesworld, was just inundated with AI submissions, and they had to shut down actually for like a good 2 months while they figured out how to detect AI. So it's clear that AI competing, AI authored submissions competing with human authored submissions is already very much here. It's not something in the future.
But maybe I should also add there, yes, what Gautam is pointing out is a crisis which almost every journal editorial board is today facing. More than 90% of the submissions are either AI generated or submissions that are generated with the assistance of AI. But can we also use it as an opportunity? For example, we have been continuing with this mode of scientific communication for a very long time, and as we know, this mode has been captured by publishers like Elsevier.
Yeah.
Maybe this is also an opportunity to rethink whether this is the correct form of scientific communication. Maybe we have to radically rethink whether this should continue or whether we should move to other forms of communication.
Yeah, I think this is a really important point, and I think this brings me to something I have been struggling with, and I think it's again something very topical now. I think everyone in this room who has at some point done, either academic work or who is a reader would have used either LibGen, or Book ZZZ, or now Anna's Archive, since LibGen has been, basically shut down for two reasons. One is that, and while this is now changing, many of the books we want to read are just not available in India, right? So when I was growing up, my favorite fantasy writer guy, Gabriel K, his books just weren't available. So I had no choice but, and this was before Amazon was a massive thing. So I had no choice but to download his books off the internet. Years later, when I went to the UK, I bought them out of gratitude, but that's a different thing. And secondly, they're expensive, right? So academic papers, $45 for a paper, right? I mean, who's going to pay that much money? Academic books. So one of my academic books is 100 pounds, right? I mean, I wouldn't pay that money, and I tell people, please, like get this book of LibGen or Anna's Archive. So basically, I mean, for us in India, in countries that are not part of the US, UK, Australia, that axis of countries, we need these kinds of forums to get access to knowledge on an equitable basis. But then I recently read that I think it was OpenAI perhaps. So they also did the same thing. So they downloaded the entire database of LibGen and they trained their AI model on LibGen, right? So on the one hand, this is emancipatory, it's liberatory, like it's giving us access. But then the same database is being used by the big tech companies to train their models on. So how do we navigate this dilemma?
So again, I mean, yeah, that's a very important question and a dilemma which is faced by people like me, because as Gautam is trying to point out, it is a fact that most of these scientific publications are priced at a level which is completely inaccessible for most of the people in this room. And it could be books, it could also be even articles. For example, Elsevier and so on, many a times charge like maybe $50 or $100 just for accessing one article. So the only savior for us was then, yes, LibGen, Sci-Hub, and so on. And as you also very well know, there was even a litigation in Delhi before the Delhi High Court.
I was in that, yeah.
The Sci-Hub litigation, wherein the question was whether we can allow this to happen.
Of course, like photocopying of course packs.
So two things actually. So one was the Rameshwari photocopy shop case, wherein the question was whether the inclusion of copyrighted materials as part of course packs is a violation of copyright infringement. Both the single bench and the division bench said no, as long as we can actually show that it was in the course of instruction. So that was one of the major victories for access to knowledge movement in India. But there was also another litigation against Sci-Hub.
Oh yeah.
Unfortunately,
it's still ongoing.
It is still ongoing, but the sad part is that the Delhi High Court granted an injunction against Sci-Hub blocking access to Sci-Hub. Of course, it's a different matter that at a practical level, it is still accessible because they have changed the links and they constantly do that. Because of that, we are able to access it. But even in a litigation like that, the courts need to be more careful. It has to actually look at what is a broader implication on the society when they grant these wide sweeping injunctions. But now, the problem is bigger because of the issue which Gautam was highlighting, because these big tech companies are also now using these sources for training purposes. So the earlier litigation I mentioned in the Anthropic case, if you look at the facts of the case, you will notice that what Anthropic did was they also built a library using these materials they accessed from LibGen, Anna's Archive, and so on. So there the court said that matter has to be going through a trial in a different track. And a part of the reason why Anthropic went for a quick settlement was that they knew that it was a losing battle. They will have to actually pay heavy price in the US for doing that. But I must also bring here a contrasting, I would say, approach taken in the Meta case, wherein you will notice that for the training of Llama, again, they had used these sources, but the judge said that as long as I am saying there is no copyright infringement, then the source really doesn't matter. Of course, at a conceptual level, I also agree with what the Meta judge mentioned, because this question of lawful access is a slippery slope. And in general, if the final conclusion is that there is no copyright infringement, the source shouldn't really matter. But yes, I admit that this is a dilemma which the world is currently facing, and we have to wait for more litigations to get more clarity here, because as we can clearly see, even within the US, different judges are actually taking different approaches with regard to use of these kinds of sources for the purpose of training.
Yeah, because I mean, technically, there is no doubt that something like Anna's archive obviously breaches copyright law, which again I think just shows us the absurdity of copyright law.
I would be a bit
Yeah.
cautious
Okay.
in saying there is no doubt. For example, imagine that I, as a researcher, is accessing materials from Anna's archive
Yeah.
for the purpose of my research. Then, under the Indian copyright law, we have an exception under Section 52.
Yeah. 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 Yeah.
There is a very high probability that I might qualify for that. But whether the same should be extended to an AI company,
Oh,
that is a
I was thinking of
debatable point.
novels and downloading novels. Yeah, because obviously like
So
yeah.
even on the
Yeah.
novel,
Yeah. Yeah.
imagine that Gautam's novel is prescribed as a reading material
Right. Right.
at the University of Calicut, and of course Gautam has pushed to push the publishers to price it at a lower level. But imagine that it was priced at 10,000 rupees or 20,000 rupees. The students in University of Calicut is downloading it for the purpose of their
Right.
education.
Yeah.
Most
Yeah.
probably they might have
Yeah.
qualified
Yeah. Of
under the
course.
fair
Yeah.
dealing
Yeah. Yeah.
exception.
Yeah.
So,
Yeah.
or under the educational use
Yeah.
exception.
Yeah.
So, um, there is still a scope for arguing, but yeah, there is no wide sweeping, I would say, usage right there.
Yeah, I mean, one of the arguments that I had tried to make or push in the OpenAI case was that the researchers accessing Anna's archive, for example, or those Sci-Hub actually can't afford the original article.
Yeah.
So there's no question of market substitution. But again,
Absolutely.
we had to withdraw our case out of that, so it didn't finally happen. But yeah, I think, like I said, I mean, the real difficulty is that how do you ensure that the people who, because of copyright law, are unable to access, educational materials or literature, culture, and so on, can access them in these ways, while tech companies are off limits. So I think that's the really tricky
Tricky issue.
question that's there.
Completely agree with you on
Yeah,
that.
yeah. I think we have around 14 minutes left, so let me open it up for questions. Yeah, go ahead.
Hi, sir. And you have touched a little about research articles and publications. So you might know that Springer Nature has first developed its own AI created book, which is based on the research, and it is made as a textbook. So how do you see that? Because it is highly uh, costing, and if it type of publishing activity comes to India, like the local publishers, like with the local publishers, how do you see that, and how it will change the education system, mainly the research area?
Yeah. So again, if I understand your example correctly, Springer has used the researchers' articles, which are
No,
part
sir.
of Springer
Actually, it
publication.
used A, that is
Yeah.
ChatGPT, to use applications of ChatGPT in
Creating a
finance
book.
audit.
Okay. So in an instance like that, there are two important things to be kept in mind. One, the authors of the works that were used as part of the original training can still sue. And as I indicated earlier, there are litigations happening in different parts of the globe with respect to this. And we have to wait and see how the courts are approaching that issue. So as it stands now, there are like more than 70 litigations happening in different parts of the globe. And my general expectation is that we will see diverging results, and most of the results are going to be very fact specific. So even when I go back to this particular example, this is going to be a fact specific thing. But something more which I should add here is that yes, publishers have taken away the rights from most of the authors before training purposes. But in a jurisdiction like ours, wherein we have a very specific provision which says that you cannot assign your rights to a technology or medium that was not in existence on the date of signing of the agreement, this is a very tricky issue. For example, I can kind of guarantee that almost all the agreements which Gautam signed, there was no provision which categorically said his works will also be used for AI training. In those instances, the publisher, say for example Springer, will be using without an appropriate permission from the concerned author. So the authors have a very strong case there. So one of the things which the authors should do, whether you are dealing with a local publisher or an international publisher, is that yes, you should retain some of your rights, including this particular right, wherein yes, you might want to either allow the concerned firm to use it for AI training purposes or not. You can even say specifically in the agreement, I do not agree for allowing my work to be used for the purpose of training by this particular publisher. I think that's the way forward.
I'm a tech policy researcher doing a legal landscaping of AI and copyright issues across 14 countries. I work at Apti Institute. One thing we could see is US, Canada has a lot of cases. Asia, especially Singapore and Japan, have taken a quite a AI friendly approach. And then you can see India and Kenya, which has almost no discourse till India's recent working paper. How do you see, is this also an issue where creatives, like, because India does not have a lot of collective creative industries who are actually fighting against something like an AI usage, does that actually have an effect? This is particularly in reference with Australia also. Australia, they tried to implement a fair dealing exception, but it was prevented by the industry, especially the collectives. So do you think that's an issue also?
So the Indian situation is kind of very interesting because on one side, you will see the government constantly saying that we don't want to miss the AI bus. We need to allow the startups in India to like build models, and even maybe at times we also hear the ministers saying we want to build large language models. If that is the case, yes, it is quite clear that we need to have more exceptions under copyright law or a more liberal approach to copyright law. But what is interesting is that in the Indian context, copyright comes under the Ministry of Commerce, and the Department for Industry and Industrial Promotion, DPIIT, is currently looking after the Copyright Office. And even if you look at the recent working paper, you can very clearly see that the content holders, particularly the music recording companies and the big publishers, have a very high influence with respect to policy making or non-making in the Indian context. So the absence of concrete steps in India is not by chance, but I think it's because of the extensive lobbying that is done by the copyright holders in India. And by copyright holders, I mean the big publishers and the big music companies and film companies.
Like the reprographic organizations.
Absolutely.
Not the individual writer or like.
Not the individual,
Yeah.
right?
Yeah.
Sir, it is a tricky issue, as you mentioned that the entire large language models are black boxes. Do you think that Wikipedia is being cannibalized by ChatGPT, or the print media entirely is being cannibalized by ChatGPT? Take an instance of deepfake. If Yeshudas is mimicked by an algorithm, can Yeshudas fight for copyright of his voice? It is an infringement. He says that his voice is being infringed. Can Yeshudas file a copyright infringement litigation?
So again, I mean, as at least some of you might have also seen from news reports, now many of the famous personalities in India are approaching courts, particularly the very liberal, IP liberal Delhi High Court for protecting their voice, likeness, etc. And most of the time, this is happening outside copyright law because copyright law has much less to do here. But there is a so-called branch called personality rights. Again, we don't have a codified law there, but the courts use a mix of laws, including the common law remedy of passing off, and then have been giving sweeping remedies, be it singers, be it other kinds of personalities. My general view on this is that the courts need to take a slightly more careful, more balanced approach there. They shouldn't grant sweeping injunctions in instances wherein there might be deception of the public. For example, if I am creating an audio output with Yeshuda's voice and not declaring upfront that this is not Yeshuda's but me who has done this with the help of AI, then there is a problem. But if there is a proper declaration which is communicating to the public that this is AI generated voice, I don't see much issues happening there. But most of the time, the courts are issuing wide sweeping injunctions. And this is now not just the Delhi High Court, but other high courts like Madras High Court, Bombay High Court. All these courts are also doing something similar in this particular area.
I think there's a question back there somewhere. I saw a hand up.
A couple of quick
Sure.
questions. So, if a person creates an art with the help of AI that no human has ever seen, will that be considered as a descriptive art? And also, you mentioned that prompts would be outside the purview of copyright.
Yeah.
I was wondering, like prompts that runs 1 or 2 pages, it shows the creativity and expertise of the creator. So, would that also be outside the purview of copyright, especially since we have copyright protection for translated work? So those are my questions.
So again, I mean, a very good question. So as I indicated earlier, one of the conditions in almost all the major jurisdiction for copyright protection is that the work must have originated from the author. So irrespective of the fact that you have produced an absolutely novel work, it wouldn't get copyright protection. And as I mentioned in the context of the example from the US, because that's a place where we have seen maximum litigations on this front, even in cases wherein, yes, people have used more than 500 prompts to fine tune, and then produce a particular piece of art. And in one instance, this concerned piece of art actually won the first prize in an art festival. And then this particular person declared that, yes, he had used AI. But in spite of that, the courts clarified that there cannot be copyright protection. So, irrespective of the number of prompts, the legal position remains the same. And that's again a justifiable thing because copyright law was created by only seeing human beings in mind. And at least in my view, it should remain the same. That's the general take.
Yeah, just on that, I mean, there is a fantastic piece by the science fiction writer Ted Chiang a few months ago, and I recommend it to everyone here, where he actually points out that what sets apart human creation is the struggle that goes into the act of creation, and that struggle brings with it various flaws and errors and mistakes, and that is the essence of human creation. And that's why actually AI can't replace that. So yeah. Was there a question somewhere there?
Me? Hi. I'm not sure how relevant this question is in a conversation about copyrights, but I'd like to bring everyone's attention and perhaps even get your opinion on this whole phenomenon that's happening in the virtual world where Grok, an AI assistant, is virtually stripping female users. They with a chat prompt, they are asking to put bikinis on them. Not just women, even children don't escape this. So I'd like to know your opinion on this, and why are we debating the legality of this right now? Grok has, with a after a lot of pushback from the users, Grok has now put this option behind a paywall. So they essentially benefiting, they're minting money through this. So I'd like to know a little bit about this.
So I think the issue which you are highlighting is definitely a matter of concern, and this has to be addressed. So the issue of deepfakes has to be addressed. The only question is whether we should address it from the perspective of copyright law or should we actually look outside. So even if you look at, say, for example, the IPC or BNS, yes, if you are actually using the provisions properly, there are solutions. But ideally, yes, India should also have an AI regulation in place. But as I indicated earlier, there are also different stakeholders pushing back against strong regulations. And in this particular context, it is the startups and other, I would say, the tech companies which are pushing back against a strong AI regulation. So yes, we need to definitely address the issue, and I'm sure
I mean,
Gautam
when
will
this happened,
also
like when the UK threatened to actually ban X, after they were doing this, to UK users, and I think that's when they did this paywall step and or your verified account thing. So maybe like what you need is for governments to actually step in and say that either you remove this functionality altogether
Absolutely.
or you just get banned. I mean, you're out, and your like CEO will be like put in prison, right? So I mean, you can't really deal with this except for saying that either this functionality goes where nobody can do this,
Yes.
or you're banned, right? So
No, that's a place where a strong and risk-based regulatory approach is very much required here, because I mean this technology, while it has many, I would say, positive sides, it also has many threats like what you are trying to describe, and a proper regulatory framework is definitely a necessity here.
yeah, I think we're out of time, unfortunately. 45 seconds left, maybe no more time. Thank you for coming, and more questions, please ask them outside the hall. Thank you.